Good afternoon. Today is Wednesday, April 24th. We had one review session this morning at Wake. As promised, I'm going to finish the Younger v. Harris doctrine today and finish the Colorado River stuff so that this will be the last substantive matter. So let's go back over Younger v. Harris real quickly here. Remember, Younger is on page 1127 of the book. It's a 1983 action brought in federal court to enjoin a pending state prosecution under a California Criminal Syndication Act that was probably constitutionally overbroad. The Supreme Court held that absent an exception, a federal court may not enjoin a pending state criminal action. Why? Two reasons. Equity courts typically don't enjoin actions where there's an adequate remedy at law, and the argument is that you can have your constitutional defenses raised as a defense to your criminal prosecution. And secondly, and most importantly for Younger v. Harris, is the notion of comity and the notion of federalism, our federalism. Keep in mind that a state criminal action is one form of an enforcement proceeding. So as we'll see, we have to have two ingredients here: a pending proceeding, one that looks like an enforcement proceeding of some kind. So administrative proceedings to get civil penalties or forfeiture of property might fit under the Younger v. Harris doctrine. As I said, pending and enforcement are important concepts, and we'll look more about them. So the usual area for Younger, not usual, but most common, is probably a criminal case where a free speech defense rises. Usually First Amendment, but you can think obscenity laws, laws against inciting revolution, disorderly conduct, trespassing laws. A lot of this stuff comes up in protest from the Vietnam War. We'll see some cases from other areas, but there are clearly more cases from the First Amendment area than anywhere else. We've discussed some other barriers to access to federal courts, and we can should talk about Younger in comparison with those, and we'll spend more time about that. So how does Younger compare to Pullman abstention and or certification? Younger is a dismissal of the federal action. Thus, it's more like Burford abstention than Pullman abstention or certification. Younger abstention does not merely delay a federal action, it ends it. It's like Burford, and like the domestic and probate exceptions that I'll talk about later today, it totally ends the federal case. So we can make the following qualification here about Younger. Younger is harder on the federal plaintiff than the Anti-Injunction Act that we talked about the other day, in that the Anti-Injunction Act, by its name, only applies to injunctions. Younger also applies to declaratory judgments as well. So if you're in a Younger v. Harris situation, the whole case is gone. If you're in an Anti-Injunction Act situation, your right to an injunction may be gone, but the federal court can still hear your declaratory judgment action. So what happens if the plaintiff comes back to federal court for enforcement of his federal rights after the state action is over? Probably cannot do it, more so due to res judicata than the Younger doctrine, because if you're in the criminal context, you're going to have to raise your First Amendment issues in that state court proceeding. So let's talk about exceptions to the Younger abstention. Different people characterize these different ways. First is a bad faith harassment, which this is the Dombrowski case, which is discussed at page 1131 as part of the Younger decision itself. It's a situation where the prosecution is being brought, quote, without reasonable expectation of obtaining a valid conviction. You have to show that it's for harassment purposes. And here, the reason for this is because one's rights can't be raised in the state proceeding because the constitutional violation is the necessity of having to appear and defend the bad faith state proceeding. Dombrowski is an example of this, and there has never been another Supreme Court case that I know of that follows Dombrowski. It rarely works because it has to be terribly egregious. So let me give you an example. Let's assume that you've got a county district attorney who is just dedicated to getting rid of adult bookstores in any form or fashion, and she loses 90% of the cases. But when the bookstores try to get a federal injunction against more cases, the federal courts are going to ignore that request under Younger, because even a small success rate of 10% is going to negate the bad faith charge. And so Dombrowski may be a situation that is unique. So a second exception is a combination of a biased tribunal or unavailability of an adequate state forum. And if you have a biased tribunal, by definition, you don't have an adequate state forum available to you. Gibson v. Berryhill on page 1143 is an administrative proceeding involving a person who wanted to practice optometry at a chain store in spite of a state law that said you had to do it in a private practice. So his claim was that the state agency, the state administrative agency in charge of adjudicating this, is made up of members who have a financial interest in the outcome because it's made up of private practitioners. And the court there said he could maintain a federal lawsuit instead of being forced to present his federal claim only as a defense to the state administrative agency because of that financial interest. And thus, that leads to the conclusion that that state agency is a biased tribunal. Does the plaintiff have to show that the members of the board are actually biased against him? The answer is no. It's not just the actual bias on the part of the state judge or state administrative agency, but it also goes to situations where there is a structural potential for bias. Gerstein versus Pugh, which is not really discussed in Hart and Wexler, the state defendants, federal plaintiffs, were pretrial detainees, and their claim was a due process clause claim that required that they be given a prompt hearing on their detention status so that there could be a determination of whether there was probable cause to keep them in jail. And the court said that they had a right to federal court. Younger abstention doesn't apply because the state criminal court can't hear this pretrial detention issue as a defense to the underlying substantive state criminal charge. So even though there's a state criminal action pending against these defendants, federal plaintiffs, they can't raise that in the substantive state proceeding, the trial on their criminal charges. And thus there's no federalism or comity barrier to the federal court challenging the state's lack of a probable cause hearing. So that's an example of the unavailability of an adequate state forum where there is not bias being shown. Another potential violation is one that's in Younger itself. At the very end of it, it's at the very top of 1134, where Younger abstention would not apply to a situation where the statute at issue flagrantly and patently violates the Constitution. For example, an Alabama law that says the First Amendment to the United States Constitution shall have no application within the state borders of Alabama. As far as I can tell, the Supreme Court has never had occasion to apply this phrase. So let's turn now to another part of Younger that we haven't talked about yet, and that's about Dombrowski, but it's not the bad faith part of Dombrowski. The plaintiffs in that case were civil rights workers in Louisiana, and I'll point your attention to page 1131 after the bad faith part. The civil rights workers claimed that they were being threatened by the authorities with prosecution for activities protected by the First Amendment. They ultimately got injunctive relief. The court gave two grounds in Dombrowski for giving that injunctive relief. First, the bad faith notion that we already talked. The federal plaintiffs, and the second ground is that the federal plaintiffs claimed that the state statutes were overbroad. They covered much protected speech in addition to matters that the state could arguably have legitimately made criminal. And part of the court's opinion in Younger discussing Dombrowski suggests that there is an exception for overbreadth challenges on the ground that such a statute has a chilling effect on protected speech so that it must be struck down as soon as possible, and that a federal challenge like was brought in Dombrowski is a good vehicle for doing this. After Dombrowski, in the 6-year period between 65 and 71, there were tons of cases in the lower federal courts on exactly this premise. And the court could have distinguished Dombrowski, let me back up. In Younger, the court could have distinguished Dombrowski because Dombrowski was not a pending criminal proceeding, only a threatened one. But instead, the Younger majority expressly rejected the overbreadth part of the Dombrowski opinion. So according to Justice Black, who wrote in Younger, he said there is no overbreadth exception to Younger abstention. So look at pages 1132 to 1133. Part of his reason is that it's the federalism one. But in addition, that the court said the overbreadth reason is not to be, generally should be avoided, because the role of the courts is to decide cases and not to review for defects, as the overbreadth doctrine invites. And interestingly, for another part of the discussion, look at mid part of 1133 in Justice Black's opinion. He comes back to the law saying versus dispute resolution notion from Marbury versus Madison that we've talked about time and time again. And he says that law saying arises from the primary role of the court in dispute resolution. So that part, there are not many overbreadth challenges, so it's not as big a deal as some of the other stuff is done, but it's important. So remember, in coming out of Younger, you have to have a pending state proceeding that looks like an enforcement proceeding, like a criminal prosecution. A few years later, we get to Steffel v. Thompson, and I talked about this briefly in class the other day, mainly because I wanted to show off what I was doing 45 years ago at North DeKalb Mall. Steffel happened a few years before this picture was taken, my yearbook picture. So pamphleteers were outside of North DeKalb Mall, and the interesting thing, not discussed in the case, was my initial reaction to this is, well, wait, North DeKalb Mall is a private piece of property. So why isn't this just a straight trespass thing with no First Amendment attached to it? And the answer, this is not a full answer, but the answer essentially is North DeKalb Mall let all kinds of other people do things out on their sidewalks, from Boy Scouts to people selling things to other kinds of pamphleteers. They essentially had created almost like some kind of a public forum there. So these were people protesting against the Vietnam War. The police come and say, look, if you don't leave, we're going to get you for criminal trespass. Don't come back. So Steffel leaves. Shortly later on, his friends come back. They get arrested. And Steffel is told that if he does this again, he is going to get prosecuted. So the court there said, well, Younger abstention applies only to pending state court proceedings, not merely threatened one. So here, he's threatened. He's got enough threat of an injury to surpass the standing requirement inherent in Article 3, but he doesn't have a pending enforcement proceeding. So therefore, the court says you can get declaratory relief, and Younger abstention does not apply. So why is that distinction, pending and non-pending, important? Why did the court say that in a non-pending situation we can go forward with the federal case? Think about the federalism issue. In a non-pending situation, there's no state case, so there's no duplication, there's no disruption, no quote-unquote disrespect to the state court, no state forum in which to present your federally based claims, your federal law-based claims. So the focus here is not really on deference to state courts, but only deference when the case is pending, actually. So, but STFL and its pending/non-pending distinction have endured. So that if you get a Younger abstention question, look quickly to see if it's a pending matter or if it's not a pending matter. Now, there are cases in the readings that I'm not going to get into as much, but we have to look at how we define the term pending, which is who filed first, state or federal. Does it matter if the state filed first? Maybe, but what the court's going to look at is if a state proceeding is filed first, that's going to rule. But what if the federal procedure is filed first and then the state files? Well, the court typically says if the state court procedure starts before any meaningful proceedings of substance in the federal court action, the federal court will back out. That's what happened in Hicks versus Miranda, which is where the police seized copies of Deep Throat, arrested 2 theater employees. The theater owner, who was not among those being prosecuted, files a federal case to have state obscenity charges, the state obscenity law declared unconstitutional. So the next day, arguably in retaliation for the filing of the federal lawsuit, the state prosecutor arrests and brings charges against the theater owner. The Supreme Court ultimately holds that Younger abstention applies because the state criminal proceeding began before there were any proceedings of substance in the federal court. Look at that last bullet point. That's important. This gives state prosecutors the power of what's known as reverse removal. That drives people crazy. Hicks v. Miranda is not a good decision if you believe in individual rights. So, granting, let me double check slides here. Okay, granting that Younger does not apply in cases where there is no pending state proceeding, does it follow that an injunction is appropriate? Well, look at pages 1146 and 1147 in STFL. There the court says a DJ is appropriate, but it doesn't speak to an injunction. From reading this, you might think that the court had made some kind of compromise between plaintiff and defendant interest and had decided that some lesser form of relief, a declaratory judgment, is less intrusive than an injunction. But look at the practical reality of it. If you get a declaratory judgment as a plaintiff, you're probably just as good as having an injunction in a state criminal proceeding because it's going to be res judicata against the state. And then, maybe more importantly, a declaratory judgment can form the basis of an injunction if the state prosecutor does something inconsistent with it. Because the federal courts under the Anti-Injunction Act have an exception to protect their own judgments. So remember in the area of absolute immunity with judges, the one way that you go after the judge is you get a declaratory judgment first, and then you get an injunction against the judge. This is the same notion here in the Younger versus Harris abstention doctrine. Because if you get that declaratory judgment in your favor and the state does something to violate it, the federal court's going to give you an injunction immediately, despite the Anti-Injunction Act, because it's an express exception to that. But that's the way in the 40 years since Steffel the lower federal courts have treated it. So we know from Steffel that a plaintiff can get a declaratory judgment. Let's go back to the Steffel slide. We know that from Steffel that a plaintiff can get a declaratory judgment if no state prosecution is pending. Can you get an injunction? You can get declaratory judgment, but now can you get an injunction? And the answer seems yes. If you look at note 4 after Steffel on page 1156, there's a case, Woolley versus Maynard, that the Supreme Court, without much discussion, found that injunctions are appropriate in the Steffel fact pattern, meaning there's no pending prosecution even though there were prosecutions of others. So in practice, there remains a pretty sharp pending versus non-pending distinction. So let's look at the flip side of that question. Can a plaintiff get a declaratory judgment if a state case is pending? So suppose there's a pending state criminal prosecution. The individual is trying to escape the comity and the equity rule by seeking a declaratory judgment, not an injunction against a pending state claim. What he's essentially saying is the state criminal prosecution can go forward, but federal court, I want a declaratory judgment that the state law is unconstitutional. So the old rule of equity, what would happen in an equity court, probably wouldn't apply with as much force here, which is why I said the other day, you need to view this in one way, looking at through the lenses of equity, and the other way through the lenses of federalism and comity. But the comity-based rule applies here because with comity as the key consideration, in a case decided the same day as Younger, and there were like 7 cases decided the same day as Younger versus Harris, all having to do with aspects of this doctrine, the court said the declaratory judgment was also forbidden if there was a pending case where that issue could be raised. That's the Samuels versus Michaels case on page 1145. It's discussed in Steffel, decided the same day as Younger. Again, the key distinction, the factor that does the work of distinguishing the cases in one camp versus those in the other camp, is the pending, non-pending distinction. The notion of whether you're seeking injunction versus declaratory judgment doesn't seem to carry the day. It's the pending versus non-pending distinction. So another thing we should think about with Steffel is go back to Younger for a second. Remember that Harris was prosecuted, but there were several interveners, Jim Dan, Diane Hirsch, and Farrell Brosklowski, joined in saying that they felt threatened too. They felt inhibited. So look at pages 1128, 1129. They had not violated the law, arguably, but they say, look, this prosecution of our friend Harris makes us feel like we're chilled. We can't do this. The Supreme Court affirmed the dismissal of their suits because they allege only that they felt inhibited. The Supreme Court said that they had not alleged any fears of state prosecution that were imaginary or speculative. We could talk about this as a lack of ripeness. We could talk about this as the lack of the distinct and palpable injury needed for standing. Remember, in Steffel, he was threatened with imminent prosecution. That meets the standing burden. feeling inhibited, feeling chilled is not enough in the Younger v. Harris doctrine to get you there. You might also could express it as whether there's an irreparable injury if you've not been threatened with imminent prosecution or actually prosecuted. So the difference is here is Stoeffel had said that I was actually threatened by the police. I'm not making this stuff up. This is not imaginary or speculative. So at the time of Stoeffel, some people thought that this was a narrow exception to the Sila and what was known as the Sila and Charybdis of Younger on the one side and the rightness doctrine on the other side, which would keep state challenges to state criminal statutes out of federal court. Look at page 1150 in the middle in Justice Stewart's concurring peering. He said this is going to be exceedingly rare, and he thought that the threatened prosecution, what happened in Stoeffel, would be a rare, narrow category. And it has not turned out that way. In fact, it's turned out that many anticipatory cases can be brought under the Stoeffel principle and have been. So, we just talked about Hicks and this notion of the power of reverse removal. Let me talk about another case, the Duran case. In that case, 3 bar owners file a challenge against a newly enacted ordinance on topless dancing. The plaintiffs sought both declaratory and injunctive relief. Now, there's no pending state case yet. But the federal court, district court, denied a TRO. So bar owner number 1 said, we've got this case pending. I'm going to resume topless dancing at my club in arguable violation of this newly enacted ordinance. Bar owners number 2 and 3 said, okay, we're going to obey this state ordinance or local ordinance, but we're going to fight on in the federal case because we lost the TRO, but we can get a preliminary injunction and ultimately, we can get to the merits of our case. Owner number 1 gets prosecuted in state court. Criminal violation. So what happens? Subsequently, the district court grants the preliminary injunction. This is a little bit unique because usually if your TRO is denied, your preliminary injunction is denied. On the flip side, the granting of a TRO does not necessarily mean that the preliminary injunction will be granted. Here's the interesting case. The Supreme Court affirmed the preliminary injunction as to bar owner numbers 2 and 3 because they were threatened, but they had not been prosecuted, and they didn't. And this actually, you could argue that as to bar owners 2 and 3, this is not a Younger v. Harris case because you could say there's no pending matter. I said they were threatened, but that's not true. They never violated the ordinance, so they couldn't be threatened with prosecution for what they were doing. They just went to federal court and filed an action on the constitutionality of the state of the local ordinance. So the Supreme Court ultimately affirms the injunction in the ruling in favor of bar owners number 2 and 3, but reversed it as to bar owner number 1, the guy who had been prosecuted, and the court said, this is a classic Younger situation. As to bar owner number 1, there's a pending state court prosecution. And under the Hicks doctrine, remember the Hicks doctrine says that if the federal lawsuit starts up and before there are meaningful procedures on the merits, the state prosecution then cranks up. Younger versus Harris dictates abstention in favor of the state prosecution. Terrible decision, but that's the rule. But here, look what happened. There was a TRO hearing. It was denied. The Supreme Court in Duran says that is not a substantive procedure on the merits. Maybe the argument is that a TRO can be an ex parte proceeding, but that looks like a substantive procedure on the merits. So take that for affirmation of the Hicks case, but also a side note that doesn't come across oftentimes in coursework like this is the court looks at defendants not as a group, but under their individual circumstances. Just like we said in the standing area, that you have to convince the court that you have standing for each of your separate claims. Just like in a cert petition, you may ask for cert on 3 issues. The Supreme Court may only take cert on 2 issues. Let's say you've got an adequate and independent state grounds case and you certify 3 issues. The court may say 1 and 2 are fine, we're not going to hear 3. So notice you have to differentiate among these people. So that's the Younger v. Harris doctrine. Let's talk about the last, what's called abstention, but the Supreme Court tried to not use that label. And it's the issue of parallel proceedings, the Colorado River case on page 1171. It's a judge-made abstention doctrine. It's called the deference to parallel state proceedings. And in this case, I've put the facts up on the slide. It was a federal court action on a declaratory judgment relating to water rights among Indian tribes, states, everybody else. One of the federal defendants sought to add the United States to a party to a state court action. And I use the phrase state court action, and that's its functional equivalent, but it was in an Indian tribal court, which serves the same role. The McCarran Amendment allows the U.S. to be sued in state courts in certain instances. It's a waiver of sovereign immunity. And then other federal defendants moved to dismiss the federal action for lack of subject matter jurisdiction, saying that the McCarran Amendment puts this in state court. The district court dismissed the case based on abstention grounds, said, you're right, we should dismiss the federal case. The 10th Circuit reversed, saying Younger doesn't apply, Pullman doesn't apply, Burford doesn't apply, Thibodeau doesn't apply. And the Supreme Court reversed and reinstated the stay, saying this is a proper time to defer to state court proceedings. Now, the Supreme Court opinion goes to great lengths not to call this abstention, but everybody does. It recognized that this doesn't fit into the existing abstention doctrines. The court recognized that the duty to exercise jurisdiction is essentially mandatory where jurisdiction is proper. But here's the big federal court's but, the last bullet point, truly exceptional circumstances can justify abstention. So the court looks at 4 factors here. Problems that can occur when the federal and state are assuming jurisdiction over the same raise or property, the relative inconvenience of the federal forum, the need to avoid piecemeal litigation, and who filed first. So in the Colorado River fact pattern, there weren't many meaningful proceedings in the district court yet. There was extensive state law issues at play. There was a 300-mile distance between the federal court and where the state court sat, and the existing participation by the United States government in the ongoing state court proceedings. So the court, this is just a straight out deference to a pending state court action. So does it follow that federal courts should generally abstain in favor of state proceedings? The answer is no. We find that on page 1179 in note 2 after the Colorado River discussion, and that's the Moses Cone case. That's a dispute over the interpretation of an arbitration provision with one party suing in state court, the other party suing in federal court over the same issues. One of the points in that issue is whether arbitration is required is a federal law issue under the Federal Arbitration Act. And the court ruled against abstention. And in part, it's because of a point that the Supreme Court made in Colorado River, which is this analysis is weighted heavily in favor of exercise of federal court jurisdiction. Among other factors in Moses Cone, there's no state statute similar to the one in Colorado River that set up a process for adjudicating water rights. The state court wasn't more convenient. The paramount Colorado River rationale of avoiding piecemeal litigation wasn't at issue. And the presence of the federal law issue, the Federal Arbitration Act, was a big deal here. What this case stands for, the Moses Cone case, stands for the fact that abstention on the basis of a parallel state proceeding is rare. It should be the exception, not the rule. There are cases, however, where Colorado River abstention is implied. So look at the Wilton case, note 3, page 1180. This is an insurance coverage dispute, and I think an important feature of the Wilton case is that all of the issues were governed by state insurance law. The federal case was a declaratory action, judgment action brought by an insurer against the insured. The insurer wanted a declaration of non-coverage, and it filed first. The state case was a breach of contract case filed by the insured against the insurer, where the insured says, I suffered losses, my policy covers it, and the insurance company didn't pay. And the federal district court judge dismissed the federal declaratory judgment action, and the Supreme Court upheld that ruling. And I think the driving factor in Wilton is the Federal Declaratory Judgment Act, which says the federal court may grant a declaratory judgment, implying at least that there's a greater deal of discretion than is ordinarily the case. So, despite the quotes that we have in the materials, I think it's a mistake to draw the inference that Moses Cone presumption against Colorado River does not apply in declaratory judgment cases. The key feature in Wilton was that everything's under state law. So you just need to know about that. And Chemerinsky recaps, there's a great recap of factors from the lower courts in Chemerinsky in pages 928, 929, because he makes the point very well that the Supreme Court has not been very clear, and so you have to look to what the lower courts do in these situations. And so there are a set of factors that have kind of grown up among 4 or 5 circuits that he talks about there that you should at least be aware of. Because, you know, when you get to these cases, we don't spend hardly any time on circuit court decisions. Probably one of the only ones we've ever talked about is the Battaglia Second Circuit case that on the law that took jurisdiction out of all the courts. But when you do this in practice, you've got to go look at what your circuit court has done, what your district court has done, your circuit court. Obviously, you have to know what the Supreme Court has done, but then you need to see if there's persuasive authority from other places. So the last subject we're going to talk about is the domestic relations exception. This is not an abstention doctrine at all. That's not what we're talking about. We've now moved to a totally different thing. We could have and maybe should have done this when we were talking about diversity jurisdiction early on in the course. The Ankenbrandt case at page 1181 confirms that there is a domestic relations exception to federal diversity jurisdiction. In that case, the court says neither Article 3 nor 1332, the diversity jurisdiction statute, has an exception for these matters, but the Supreme Court has held that federal courts may not hear cases, quote, involving the issuance of a divorce, alimony, or child custody decree, close quote. So it's important in defining that domestic relations exception to those 3 situations: issuance of a divorce, alimony, or child custody. If it involves something else in the area of domestic relations, the exception does not apply. And the reason for this exception is because the states have historically handled these matters. They have a level of expertise. And plus, the states have a support system that have grown up around these kinds of issues. If you ever do family law, God bless you. Because I don't do it. I've been close to it enough to know that I would never want to do it in my entire life, but some people do it really well, and it's a very valuable service. Now, in Ankenbrock, that exception didn't apply because the matters didn't fit within those three categories, but it was a tort action alleging that the dad had abused his children, which is a tort, not a matter of a child custody degree. And another issue in Ankenbrock came up was, well, we should abstain to the state system under Burford. It's a complex issue of state regulatory stuff. And the Supreme Court said, nah, torts are easy. It doesn't apply to Burford, and so we're not going to go under Burford. The same reasoning applies to probate and administration matters. And it's for exactly the same reason. You've got the probate court that deals with that. There's not really the same kind of support mechanism there, but the court, as we'll see in a minute, talks about the difference between in rem and in personam actions. And probate is more of an in rem action, and the court there is saying that state courts are uniquely suited to do those. Perhaps it's fitting that we end this with coming back to Vicki Lynn Hogan, Vicki Lynn Marshall, also known as Anna Nicole Smith, the Playmate centerfold of whatever month she was centerfold on. J. Howard Marshall, who had divorced one wife and outlived another when he was 89 years old, marries Vicki Lynn Hogan, Anna Nicole Smith. She's 26 years old. During their marriage together, their 14 months of bliss, he lavished her with gifts. The strain apparently was too much for the poor guy, and he died. And for reasons that are unclear and not relevant, he did not include Vicki Lynn in his will. And the Texas Probate Court found that the will was valid, which means under the will, Vicki Lynn gets nothing. Now, as you might imagine, when a 26-year-old marries your really, 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 really rich father, you're not going to be pleased. And Pierce Marshall was not. And he and Vicki Lynn fought the entire time. He sues her in bankruptcy court proceedings in California. You will recall we saw this in Stern v. Marshall in the adjunct legislative court stuff. That's the case that we're talking about. You may remember that Chief Justice Marshall said this is not the first time that we've seen Vicki Lynn, and it wasn't. So Pierce sues her for libel in bankruptcy court proceedings. Vicki Lynn counterclaims, arguably a compulsory counterclaim, but a counterclaim alleging that he tortiously interfered with her right to receive a gift from J. Howard. So the bankruptcy court rules in her favor. The district court affirms, so she's looking good. The Ninth Circuit reverses, saying, look, that's a probate issue. And therefore, the federal courts should not have heard her tortious interference with the right of a gift claim. The Supreme Court reversed and held that the probate exception was inapplicable here because this wasn't not about making a will or the validity of a will or the administration of the probate estate. This is a claim that that Vicki Lynn, J. Howard, had made her a promise to give her a gift, and Pierce tortiously interfered with that promise. Almost like a tortious interference with contract or tortious interference with a prospective business arrangement kind of claim. So the Supreme Court says that the probate exception is usually based on property, usually based on real property, and speaks in kind of in rem terms that you may remember from your property course. And Vicki Lynn is seeking an in personam judgment, not against an estate, but against Pierce himself. She's not seeking the probate or invalidation of the will, and she's not seeking to reach the race, the bundle of sticks that's in the custody of the state court in a probate proceeding. And thus the Supreme Court said the probate exception does not apply. So what you want to think about that for purposes of diversity jurisdiction, if you have something that looks like a domestic relations issue or something that looks like a probate issue, you need to dig a bit deeper to see if it falls within one of these exceptions where the federal court is not going to exercise jurisdiction. And again, remember, this is not abstention. It's not a situation where the court says, otherwise we have jurisdiction, but we're not going to exercise it. Here, it's an exception to the diversity statute in Article 3 that has just come about over time. So with that, that's the end of the materials through page 1192. I hope you've gotten something out of this. Again, if you need me before the exam, email me. I'll be happy to talk to you on the phone since I won't be on campus all that much. And I wish you the best of luck. Thanks a lot. Have a great evening.